Right, okay, well, hello again everybody. Day 2 of the inquiry, and I think there's been some developments since the last time we were here. So I think nobody's here that's from members of the public or anything like that, so I'll take the normal housekeeping things as read, and let's hear from the council please about what the position is.
Yes, so thank you. So obviously, we're mindful of the evidence that was elicited during cross-examination on Tuesday, and in light of that evidence, which included some concessions that were quite important to the council's case on parking, my clients obviously heard that evidence, and Annabelle Hemmings in particular, as the responsible planning officer, obviously in light with her professional obligations, felt it appropriate to consider the overall planning merits of the case in light of what was heard and what was conceded. And as I indicated in my email to your case officer, it's her professional opinion that the tilted balance wouldn't be engaged, and therefore, in light of the development plan and other material considerations, her professional opinion now is that the appeal should be allowed.
Right, thank you for that, and I understand the appellant is aware of that.
Yes, we are, sir. As I say, we're grateful that that review of the case has taken place.
Good, thank you. Well, thank you for bringing that to our attention at the earliest opportunity. Has the council prepared any more detailed statement of reasons for the change of position and what it now considers the planning balance to be?
No, sir, but I was intending that we would put in, instead of it wouldn't be traditional closing submissions, but at the time of closings, we would also put in a much shorter statement than we would have, just so that you have a written explanation of that as well, addressing exactly some of those points as to, I don't want to speak for Ms. Hemmings, and of course, we're happy to answer questions and she's happy to answer questions. I think the judgment is that there's still some level of harm potentially to parking and highway safety, but it's not at the level, nowhere near as the level that was previously thought to be the case prior to cross-examination, and in light of that, obviously the overall balance has changed.
Yes, okay, understood. Well, I think that's useful to know, but I want to hear Miss Hemmings'
yes.
evidence on that rather than just submissions from you, Miss Burke. So, can a statement be prepared as an addendum, really, to the proof of evidence, which explains what's happened and what your opinion now is on the matter?
Yes. When would you like that?
Well, we'll have. I'm thinking by the end of today, by 5 o'clock.
Okay. Yeah.
I'm not expecting it to be lengthy unless you tell me otherwise.
No, it won't be.
No. And I'm thinking we'll deal with conditions and section 106 obligations this afternoon, and potentially a site visit if that can be arranged. Yes. Good. And
we'd already discussed that between ourselves, and we thought that because Mr. Jenkins is still here today, so that he can attend the site visit, along with the council's representative, and we thought both of those things were appropriate.
Good, thank you. So the reason I say 5 o'clock for the statement is then that it gives advocates a chance to see what your new position is, and then we can reconvene tomorrow at 10 o'clock to hear a brief sort of closing of the case. Does that suit everybody?
Yes, sir, that's fine by me. Although I might ask until 11 o'clock just in case.
Yes, okay. Good. All right. Well, that's a sort of rough outline, but yes, Ms. Prick.
Yes, sorry, can I just check, in terms of site visit, Ms. Hemmings is going to accompany on the site visit, so you just would ask for a sufficient period of time between, at some point this afternoon, for her to finish drafting the statement, because obviously if we're going straight after we finish the conditions in section 106, it might be later.
I can confirm that it wouldn't be a problem for me to see that later than 5 o'clock. I'm happy to receive that this evening. That's fine.
That's very helpful, thank you. So not necessarily 5 o'clock. Let's see where we get to today with the things that we do need to cover and how much time is left, and then we'll agree later on what time that should be. Good. Okay. So that obviously is going to cut the inquiry short, and we'll conclude matters this week. So I've had an email also about conditions, and the parties have made comments on that in response to my note.
So,
Right.
yeah, we're effectively now agreed on those matters. So we've discussed this afternoon. I've got a copy, and a hand annotated copy of that note for you now, so that we can just talk you through. But effectively, we're agreed on everything now. So hopefully that will foreshorten that quite a lot.
Excellent. Yes, if you could pass that up, thank you. We'll have a discussion about that shortly, and thank you. In light of that discussion, then I'll ask for a final version of the conditions that the parties can agree between them, and I'll also need the appellant to agree to the wording of the conditions, and that any prior to commencement conditions are agreed as well in that form.
Yes, so we've since the email you may have got from your colleagues and peers, we had a discussion on the text which you've got, and there's some minor amendments. Those minor amendments have been made to your paper copy, which you now have.
I think the inspector would like a clean
And we can do a clean copy. I mean, I'm quite happy to prepare that. If you give me a time when you would like that, I can do that. I can send it off to you tomorrow. If Miss Hannibal Hemmings would be agreeable to me doing that and sending that to you at the same time as the centre pins, that would then save you time for this afternoon, as I'm thinking about.
That would be useful, and if both parties then agree the document, and it can be submitted to me tomorrow morning before I close.
I can do that. Yes, thank you.
Good. Right, so just let's just cover off all the other housekeeping matters that I've got on my list before we go much further then. So we're going to have a statement from the council, from Miss Hemmings. There was an issue raised before the inquiry about the notifications which should have taken place at the time the planning application was made, and both parties commented on that and had sought to resolve the issue. Basically, some landowners had not been notified. Is that right?
Yes, sir. And I think you should have had a note from Town Legal dated the 17th of March, which provided you with the background to that and explained what had happened. By way of further update, and I'm afraid I don't have a copy of the email yet, but I can provide one to you if it would be helpful. You'll have seen from the correspondence that in terms of JR car parks, we had engagement with them. There was some back and forth. They were asked to confirm whether they had any issues in relation to the planning, and we've had no further response to that. So I think we're satisfied that they have no concerns about the planning, because we have been engaging with them and they've had opportunity to comment. And likewise, in relation to the government legal department, we have had a further response from them. This is the document that I can provide a copy of, where they indicate that they now do intend to disclaim the land. The recommendation is going to be to disclaim the land. They were also asked, do you have any comments on the planning? And they also haven't responded again to that. So I think they've had opportunity, no comments have been made. So consistent with the note's expectations that neither party would have any substantive comments on the appeal, that is what's transpired.
Good, okay, thank you. And I think a deadline was given of Friday last week for any comments from those parties, is that right? So that's passed. Yes, it'd be useful if you could just give me an update tomorrow, perhaps, when we come back, about what's subsequently happened from the other engagement that you've
Of course, and perhaps if I pop that into my closing, and then I'll append the correspondence.
Yes, thank you. And the council's not raising any particular issue other than noting the procedural error. Yes. Thank you. Yes, the other thing I want to understand from Miss Hemmings' note is really what the status of all the other evidence is that the council has submitted. So if that can be covered in this addendum, whether you're standing by the highways evidence that was given yesterday and the written evidence that's been submitted, and it's just the planning balance that changes, or whether it's more fundamental than that, but you can explain that. I will ask again tomorrow, but is there any anticipated applications for costs at this stage?
No, sir.
Right. Okay. Just check through my list one more time. Right, are there any other matters to be raised then before we have the discussion about conditions and obligations?
No, sir.
Right, okay. So, as I said, I had already sent a note out in advance of the inquiry raising a few matters that I'd noticed from the original list, which was in the Statement of Common Ground. Had a response from both parties, and now we've got a subsequent response. So I think probably the best thing is to work through those amendments. And so let's start with number 6, which was well, perhaps somebody could talk me through them and say what the changes are that have been agreed since I last looked.
Yeah, thank you, sir. I will do that. You raised the question on condition 6. Why is this necessary? The suggested reason refers to the amenity of nearby residents, which seem to have no relation to the requirements of the condition. You have got in blue on your hard copy sheet the council's response, and in red that of the appellants. As I see it, so the council's response still doesn't meet the reason for the condition, and whilst the appellants have no objection to the written purpose of that condition, namely to require soundproofing between bedrooms to bring the building up to modern standard of insulation, that's accepted by the appellant. It's the reason for the imposition of that condition which is not accepted, because it still retains the fact that it's a requirement to safeguard the residential amenities enjoyed by occupiers of nearby residential properties. We feel so that that's not the case. It's the reason for that condition for soundproofing between bedrooms is to ensure that there are acceptable living conditions for the occupants of the proposed development. Now you will see in your handwritten scripts a crossing out of the words "given the likely age range of tenants residing at the property." That was inserted by myself, but has now been agreed by both parties that the words "given the likely age range of tenants residing at the property" can be omitted, so that the reason for the imposition of the condition relating to its purpose is to ensure acceptable living conditions for the occupants of the proposed development.
Right, okay, that seems straightforward enough. Council's agreed that, so fine, thank you.
Condition number 11, sir, you said you would need to be a Grampian style condition. I think both parties accept that, as the works are all off-site. Currently, you point out there was no implementation clause when must the works be undertaken, and you raise the question is it necessary, appropriate to reference the requirements of a road safety audit or section 278 agreement in a planning condition. From the appellant's point of view, and I think the councillors as well, we both feel that there is a need for a Grampian condition here. We from the appellant's side do not accept what the council say in blue is a Grampian condition. It's not worded as such, the Grampian condition, and we've suggested, and I now think it's agreed between us, I now know it's agreed between us, that Grampian condition should start off in the normal format. No development shall take place until a scheme detailing the widening of the existing central refuge at the crossing of Northwood Road, complete with tactile paving, has been submitted to and approved in writing by the local planning authority. The second sentence there, that's a difference between, if I might say so, a planner's view and a lawyer's view. I take the view that operational development is the formal view because I'm a planner. But I accept also that the lawyers have an input into this, and they have omitted the words "the operational development associated with," so that the second sentence starts with the words, the approved scheme shall be implemented prior to the occupation of the first residential unit forming part of the proposed development. If that was the case, it would meet your requirements. First, it will be a Grampian condition. There will be an implementation clause, and there is no, we agree with you, so there's no requirement for a road safety audit or section 278 agreement in the condition, the wording of the condition. The reason for the imposition of condition number 11 should read, in the interest of pedestrian safety associated with the proposed development. Full stop. So, just to be sure, we say the condition should read, no development shall take place until a scheme detailing the widening of the existing central refuge at the crossing of Northwood Road, complete with tactile paving, has been submitted to and approved in writing by the local planning authority. The approved scheme shall be implemented prior to the occupation of the first residential unit forming part of the proposed development. The reason for the imposition in the interest of pedestrian safety associated with the proposed development.
Thank you. That's now agreed by the council as well. Yes. Good.
Yes, sorry, if I can just clarify, I think what happened was that when Miss Hemmings was preparing it, she copy pasted the text, and I think there was a version where things were changed and this is a version where it wasn't changed, which is why you've ended up with exactly what was in the original conditions. So it wasn't meant to be obtrusive. We've only picked that up today.
That wasn't the second attempt at the same thing. Okay.
Yeah. So,
Right, thank you, not to worry. Good. Condition 16 was about biodiversity net gain, and I think it's
before
agreed.
Tim gets to this one, I think there has now been some agreement on this, which, sorry Tim, we hadn't picked up with you. I think this was the condition about your query about whether biodiversity net gain was a requirement for the proposed development under the 1990 Act or policy, and about the officer's report suggesting there was no need for a HMMP. It's agreed by the parties that the development is not exempt from statutory net gain. There is no council policy in place, but the deemed condition will apply as per the 1990 Act, so it's not necessary to impose one separately.
Thank you. So that can just be deleted entirely.
Then so there was just two disputed conditions. Originally there were disputed conditions between the two parties. The first one related to, is the proposed car club condition necessary? You write, sir, in the light of the draft unilateral undertaking, and the council accept that its conclusion in the unilateral undertaking does not require a condition, and we agree with the council on that. And you will have noted, sir, from the draft section 106 that the car club condition has to be somewhat lengthy to cover all the eventualities. So its imposition in agreement in those contexts is, in my view, better than a condition, which is not the normal case I accept. Otherwise it gets very convoluted.
Yes, okay, thank you. Council's in agreement. Okay, thank you.
And the last point, as you mentioned, was is the proposed restrictions at 68 people necessary, having regard to the description of the development? It's the appellant's view, sir, that there is no need for a condition relating to the number of occupants of the proposed large-scale sui generis HMO to be set at no more than 68 for the following reasons. Number one is the description of the proposed development is restricted to a 68 single occupancy house in multiple occupation. Just pausing there, a long time ago, when I started off in planning, it was a case involving Wilson and West Sussex County Council. It's a 1963 judgment, and it relates to an agricultural occupancy condition where it was put in the description of development, and that was considered satisfactory to control the development of the house for agricultural purposes. Similar situation applies to one. We think the description restricts it to 68 single occupancy house in multiple occupation. Secondly,
Okay, Mr. North, thank you. I've read that, so I don't need you to read it out to me
fair
again.
enough.
I understand your position, but
Thank
it's
you.
the council's position that I want to hear about on this one.
Yes.
The explanation given is that members like the idea of it.
No,
but-
so we have
yes.
discussed it, and we don't need the condition in
You
light
don't
of
need
the
it.
description of development. Thank you.
Just for some reassurance, I suppose, for members, we do also note that the PMP, Property Management Plan, controls the ability for residents to have visitors. So that is controlled through the Property Management Plan itself as well.
Well, that would need to obviously come forward as part of a condition, but we would assume that would be in the property management plan.
Yes,
that comes forward.
the current Property Management Plan that's been provided with the application contains that, and so the council could insist upon that.
Yes, and so the council's saying that that's not required anymore. I assume that's because you accept what the appellant has set out here, the reasons why it's not required. Right, thank you. Right, anything else on conditions?
Just wondering what INQ number to give that document.
Yes, so I think if the email that was sent previously could be, I think we're on INQ5 if I'm right, and then the subsequent version would be 6, please. Okay, so as I said, if I could have a clean copy of the conditions, removing comments and the reds and blues, and just giving me the agreed wording of the conditions and the reasons. And again, Mr. North, your agreement to the wording and any prior to commencement conditions are acceptable. Thank you. And I'm assuming that any sort of minor changes that need to be made to meet the test, the appellant's content for me to do that. Yes, and the council, thank you. Good, well that's conditions. So let's have a look at obligations then, please. There is a final version of the unilateral undertaking to consider.
So would it be helpful for me just to talk you briefly through the structure of the draft?
Please.
Okay. So, first part of the deed in the normal way on page 2, we have the parties, and you'll note that the owner of the site is Nelson College London, and the applicant, an appellant in this case, R.W. Margate, is referred to as the developer. And you'll note from the recitals that follow that the owner, Nelson College, is the freehold owner of the site, but the developer has the benefit of an option to purchase the site, which can be exercised until this summer. And so that's why both parties are there. Also, as well, the mortgagee, Barclays Bank. Both the owner and the developer agree to be bound by the obligations contained within the unilateral undertaking. We then have the clause 1, we've got the definitions section. I don't think there's anything that we particularly need to pick up in those at the moment. We then have the interpretation section in the usual way. The only one perhaps to note at the moment is clause 2.8, which explains that successors in the references to parties in the deed include successors in title, and of course it's obviously anticipated that the developer will ultimately succeed as the owner once the option is exercised. Following on from the recitals, we have the clauses detailing the circumstances in which the deed and its provisions come into effect and the effect of those. We've got confirmation that the deed constitutes a planning obligation for the purposes of Section 106 and that it's entered into pursuant to that and any other enabling powers. And explaining who's able to enforce those at clause 3.3. Talking more again at 3.4 about the fact that the developer's interest is by way of an option, but agrees to the extent necessary to ensure enforceability that its interest shall be bound. explains slightly later on, is a local land charges provision. Then at clause 3.6, we've got the fact that the planning obligations are identified to comply with the requirements of Regulation 122 of the SIL regs. And obviously you have the SIL compliance statement from the County Council. Clause 3.8 details the dates on which clauses come into effect. Now 3.9 is an important clause because this is the blue pencil test. There is one provision that we are expecting you to exercise the blue pencil in relation to, sir, and that is in relation to the SAM contribution. As you're aware, neither party considers that to be necessary on the facts of this case, but it was included just in case any third parties turned up with a persuasive reason why it should be included instead. We haven't heard any such submissions at all, and so we are of the clear view that you will be needing to exercise the blue pencil test by explaining that that SAM contribution is not required. Section 4 is just miscellaneous matters, fettering, etc. Nothing for you particularly to note there. Clause 5 is the covenants and obligations on the owner and which parties have to comply with which obligations. 6 deals with determination of the deed in the event that either the appeal isn't successful or planning permission is quashed or revoked or expires. 7 confirms the developer's consent to the owner in entering into this deed in light of its option agreement over that land. Clause 8, mortgagee's consent given its interest as a mortgagee. Clause 9, interest on late payment of contributions. Clause 10, the details makes provision in relation to notices and the addresses for service. 11, clause 11 confirms that it's a local land charge and can be registered as such. 12 confirms the ownership position, and just to be clear there, sir, you'll note that 12.1 says that the owner, that is Nelson College, warrants that no other person other than the owner, developer and the mortgagee has any legal or equitable interest in the site. The site is defined by reference to Nelson College's freehold ownership. So although there were other interests within the application site, they don't relate to this deed and they're not bound by this deed because they don't need to be for the reasons that were set out in the town legal note for you.
Yes, thank you. And can I just confirm the council doesn't take any issue about the fact that there's those small parcels of land that are not bound by this?
I'm so sorry, sir. I switched off for a second.
Okay. It was just being explained that there were some parcels of land that are not bound by the unilateral undertaking because there was things like the gas units and... Right, okay, thank you.
13, waiver 14 rights of third parties in the usual way. 15, indexation to allow for changes in the value of contributions over time. 16, detailing the VAT position. 17, detailing if there's any issues with devolution. 18, what happens where the county council forward funds any project facility infrastructure for which a contribution is payable, and 19, jurisdiction to be dealt with in accordance with the laws of England. So that's the main body of the agreement. Then we've got the schedules which form part of it. We've got Schedule 1 defines the site by reference by reference to the plan. The definition of site in the body of the agreement, so in clause 1.1, is the one that defines it by reference to the planning permission. So reading the obligation as a whole, it is defined both by reference to the plan and by reference to the title number registered with the land registry, and indeed the plan is also the title plan. Schedule 2 details the notices that have to be served upon the District Council and the County Council, notification of implementation, notification of commencement of development and notification of occupation. Those are necessary obviously in order for the parties to be able to monitor the triggers and the implementation of the development, and completion as well, forgive me, over on the next page. And then finally Schedule 3, or mostly substantively Schedule 3, financial contributions. 4 rather that the parties consider necessary for the reasons explained both in the SIL statement and in Mr. North's proof. The community learning contribution, the library and archive services contribution, the adult social care contribution and the waste disposal and recycling contribution. And as previously discussed, paragraph 5 of Schedule 3, we don't consider to be necessary, being the SAM contribution. So that's all the financial contributions in Schedule 3, and then Schedule 4 makes provision for the car club scheme. And as Mr. North explained, there was quite a lot of detail that had to go into that in terms of establishment and membership. And then that the final page is obviously just the formalities for execution as a deed. Now, so I know you're obviously going to want the final executed version with you in relatively short order. We have obviously got the Easter break coming up, and I understand as well that one of the parties at Barclays who is expected to deal with this had been, I can't remember, they'd been unwell or away, but hadn't been able to deal with it anyway. And so given that and the Easter break, we are going to ask for a few weeks to get this executed so that we can make sure that we don't find ourselves in the position of someone being away over Easter and us not being able to do that. My recommendation would be that we had 2 clear weeks following Easter. I think I've discussed that with solicitor for the appellant and understand that to be acceptable. I think that takes us to Tuesday, the 20th of April. Is that Tuesday's the 21st, forgive me.
Right, bear with me a moment. Let's have a look at how that sits. Usually I would be looking more at 2 weeks or something like that, but I understand your point about Easter.
Yeah, it's really just to avoid the Easter period. Obviously, we will be trying to get it dealt with as quickly as possible. So if we have it sooner, you, sir, will also have it sooner. But I didn't want to put a backstop in that then leads to the refusal of the appeal.
Okay, so 21st of April you're suggesting? Yes, okay, fine. Well, I will... Yeah. Right, okay, so that's the deadline then, 21st of April for that. Anything else on planning obligations? Thank you. Right, I think all that remains for today then is to make arrangements for the site visit. So, first of all, who is intending to come on the site visit?
So from the appellants, we're going to have Mr. Jenkins, who's the transport witness.
Okay, and Miss Hemmings. Okay, and have you had some discussion about where exactly you want me to look on the visit? If you could pass it up then, please, because I haven't seen that. Is it envisaged? I'm assuming this takes in some of the streets that were discussed in terms of the parking.
It does. So if I just talk through it, so we'll ask Ms. Hemmings and
Thank you.
Effectively saying, well, we can park on site on the carpet in those spaces that we've then also got the bus stops for the loop, and there are 2 walking routes that can be taken to those, and probably we ought to pick up the ones that are the 150-metre bus stops as well, the slightly closer bus stops. But that should cover, I think, everything then that you need to see, sir, subject to any views the council may have.
Is there access to the building itself as well?
We can try and arrange that, sir.
Thank you. Okay. And,
And so no further additions from us, thank you.
right. Okay. Thank you. It's not too far to the site from here, I don't think. So would 3 o'clock on the site suit everybody?
I think so. We think we can get there sooner than that. No reason why. I mean, if we leave now, we'd be in the next few minutes.
Yeah.
There'll be more than enough time to be there for 2:30. I think.
Miss still got to do something like this.
Better for her to be,
Now,
and then
Yes. I think by the time people have packed up
Yeah.
and got to their cars and things,
Yeah,
let's say 2:45 then, and at those parking spaces, and we'll make our way around together. And that will also coincide quite nicely with school times, as Councillor Garner had asked that it be
Specifically asked
around
for
that sort of
yes.
time. So,
So you've done
Good.
an accompanied visit, you said anyway,
I
haven't
have,
you?
yes. Right, okay, so tomorrow we'll deal with closing submissions, and there'll be a note from Miss Hemmings later on this evening. What time realistically do you think you could have that done by?
I'm going to say I'm really not precious about when I receive that this evening. I'm not expecting it to be a tome to go through. You know, we know what our position is, so I actually don't really mind if a specific time isn't set. I'm sure that it's not going to be at an unreasonable time, as long as I don't receive it at 10 o'clock or something. If it's by say 7 o'clock this evening, that would be
That's
absolutely fine by me.
I just have to get home at a
Yeah.
certain time because I've got commitments.
Childcare
and-
responsibilities.
Yeah,
That's absolutely
it's-
fine.
Yeah,
I'm relaxed when I
I can
receive
work
it.
on it this evening, and
Yeah, so as long as
certainly
as long as
produce
you
it
can.
by
Okay.
7 or so. Yes.
Fine. Let's say 7 p.m. then, and if you could email that to the PINS case officer and obviously the appellant side as well, please. Good. Are there any other matters then to raise before we adjourn for today?
So no, other than just to confirm the time for coming back tomorrow. And as I say, I might, if it's okay with you, ask for 11 a.m. just so I can make sure everything's complete.
Yes, would that suit you, Ms. Perak? Yeah. Okay, fine. So we'll say 11 o'clock tomorrow morning. And I said yesterday, but just for the benefit of the live stream, the site visit will be an opportunity for me to see the site and the surroundings only. So we won't be continuing any discussions or hearing any evidence on the site visit. We'll simply be having a look around. So if there's nothing else for today, I'll adjourn the inquiry now until 11 o'clock tomorrow. Thank you.